Welcome back to another video. In the previous video, I talked about the exclusivity requirement in the definition of charity within the Charities Act. And this video leads on to talk about the Cy-près Doctrine, okay? And this is a doctrine that is applicable when a charitable trust fails. Okay, so let's get straight into it. The Cy-près Doctrine explained. When a private trust fails, remaining funds revert to the settlor on a resulting trust. When a charitable purpose fails, remaining funds may instead be applied Cy-près. Funds which are applied Cy-près are directed by the court or charity commission to a charitable purpose analogous or similar to the original failed charitable purpose. So, how does a charitable purpose fail? There may, in some instances, be a failure of a charitable purpose from the outset, so before the charitable trust has even come into existence. And that is what we call the initial failure of a charitable purpose. So at common law, there was an initial failure of a charitable purpose only if it was impossible to apply funds for the identified charitable purpose. So for example, giving money to a hospital that had already shut down. Now, the Charities Act Section 62, which was previously the Charities Act 1960 Section 13, has expanded on the common law position. For example, Section 62 subsection E provides that a purpose fails if it is adequately provided for by other means or is not a suitable and effective use of the available funds. So now a charitable purpose will have initial failure not only if it is impossible to apply the funds for the identified charitable purpose, but also if the purpose is already adequately provided for by other means or is not a suitable and effective use of the available funds. So circumstances where there may be an initial failure have now been liberated. So what is the application of Cy-près on initial failure? On initial failure of a charitable purpose, funds are applied Cy-près, so they are applied to an analogous charitable purpose, only if the settlor can be considered to possess a general charitable intent. So they possess a general charitable intent. Now, a general charitable intent exists if the trust creator is more concerned that the funds should be used for charitable purposes generally than he is concerned that the funds should be used for a specific purpose which he has identified. Okay, now this will be a matter of construing the trust to determine whether the settlor has a general charitable intent. In the absence of this general charitable intent, the property reverts on resulting trust to the settlor or the estate of the testator. Now, we've also got something called subsequent failure too. So we've had initial failure, we've also got subsequent failure. Now, there is subsequent failure of a charitable purpose if in three circumstances. Firstly, the charitable purpose becomes impossible to achieve. So for example, the purpose to save endangered animals when they become extinct. So here the charitable purpose has become impossible to achieve, so there is subsequent failure of the purpose. Secondly, the purpose ceases to be charitable. Okay, so for example, because of the court's assessment of whether or not on balance, the purpose will remain beneficial. In such circumstances, there is a subsequent failure of the charitable purpose. And thirdly, the purpose is fulfilled, leaving a surplus of funds. So for example, in the case of Re King, £1,000 was settled to install a stained glass window in a church. Now, the installation of this stained glass window only cost £700, so the purpose was achieved and there was subsequent failure of the charitable purpose due to this £300 surplus. So there had been subsequent failure. So what is the application of the Cy-près Doctrine on subsequent failure? Where there is subsequent failure of a charitable purpose, the trust property will, subject to the exception below, automatically be applied Cy-près. So they do not look for a general charitable intent like they do when there is initial failure. Property will not be applied Cy-près when the settlor or testator expressly provides that in the event of failure, the property should revert on resulting trust or be passed to a third party. So this is one small qualification to automatic application of the Cy-près Doctrine on subsequent failure. Okay, that was a very, very quick video, but I think that should be a nice, healthy overview of the Cy-près Doctrine. But as I say in all my videos, if you have any questions at all, then please do leave a comment below and I'll get straight back to you. If you enjoyed the video, then make sure you give it a thumbs up and subscribe to my channel. Thank you very much for watching.